Welcome to Property 24's podcast, offering the latest insight and analysis relevant to South Africa's real estate industry. Right now, the most pressing question most of us have is, what is the long-term impact of the Covid-19 lockdown? Legal expert Mieke van Rensberg joins me today to discuss what some of the ongoing contractual implications are for the property industry and best practice for this precarious situation impacting not only the economy, but South Africans across the board. Good morning, Mieke. Thank you so much for joining us to discuss, some of the crucial topics facing the property industry at this time.
Yeah, thank you very much for the opportunity, Selena.
Definitely.
It's been a very interesting time, and a whole lot of new issues have cropped up, and we really, as lawyers, we had to really think out of the box a bit and see how we can practically give advice to our clients.
We've seen a lot of questions coming through, across the industry, but particularly for commercial and residential property rental agreements during this lockdown period. What advice can you give us from a legal perspective?
Okay, firstly, there's a vast difference between a residential lease agreement and a commercial lease agreement, especially under the present circumstances. They're actually the opposite of each other. Because on the one hand, most of the retail tenants cannot occupy their properties. They're not allowed to in terms of the lockdown. But on the other hand, residential tenants cannot get out of their premises. So in other words, the question then must be asked as to whether, on the one hand, the retail tenant is in a different position because of this, and what the legal implications of that is. Usually also the terms of a residential lease agreement and that of a retail agreement is quite different. The one is far more commercially minded than the other one.
So let's tackle the commercial side of things. We know that there is this clause termed the act of God, and does it apply right now?
The general view is that it would probably apply. But first of all, I want to explain what is an act of God.
Yes, that would be
an act of God is it's also called a force majeure. A lot of people are bandying that around, and it's an event which is unforeseeable, out of the reasonable control of the parties, and which makes performance by one or both of the parties objectively impossible. So it cannot simply be difficult to perform, it must be impossible to perform. Now, the recent lockdown caused by the pandemic is actually the act of God, not the pandemic itself, but the lockdown, because the lockdown is the event which is prohibiting or preventing parties from performing. So that is basically an act of God. And what is very important is that we cannot give advice without having a look at, first of all, the agreement that was entered into between the parties, and secondly, understanding the circumstances of these parties. For example, it could well be that a tenant provides an essential service and as a result is not affected by the lockdown. What also needs to be considered is that although most tenants cannot trade from their premises, they still have stock in the premises. Or they've got a server or furniture in the premises. So it is not as if they completely lost all occupation of the premises. On the other hand, landlords also have obligations that they have to comply with. So therefore, it is very important that when parties look at their situation, they need to come to an honest agreement. They have to have an open discussion and come to a commercial agreement as to what is the best under their circumstances. What is also important is that that agreement is put in writing to avoid any future litigation.
That makes sense.
There's all kinds of practical ways in terms of which parties can assist each other. They can either agree on a rental remission, they can provide for rental holidays, they can maybe just postpone the repayment of the rental So it is, at the end of the day, a commercial agreement that they have to enter into.
And then to come back to this crucial point of occupation, and then on the residential side of things, are landlords expected to pass on the pay holidays given to them by the banks?
Yeah, there's no legal obligation on landlords to pass this on to tenants, because again, we must look at the agreement of lease. And if the tenant is obliged in terms of the lease agreement to pay the rent, then the agreement stands. But again, that is a commercial understanding that parties have to agree on. So no, there is no legal obligation.
Mm-hmm.
It might well be that people feel there's an ethical obligation on the side of the landlord, but that is for a completely different topic, and I cannot really comment on that. I'm just giving you the legal perspective. There's also seems to sometimes be a misunderstanding that all landlords have very deep pockets, which is not necessarily the case. Sometimes the tenant is in a better and stronger financial position than the landlord. So those are all factors that need to be taken into account.
And I think at this time, as you're saying, there's the legal obligations, but communication between both parties and getting it down in writing is crucial at this point in time.
Yeah, that is absolutely essential. And I think that is also the message which is being sent out even by government. If you look at the recent regulations that they've sent out, or exemptions that they've given to retail landlords, in terms of which landlords are entitled to do so-called price fixing, so that they can put their heads together and come to an arrangement with especially the smaller tenants, so that those tenants can survive.
Absolutely. I think we're all in a mode of survival at this point in time, Mieke. And then
yes, and we have to stand together in this.
Absolutely. And crucial to, just our overall well-being is just, it's so difficult, facing the next, we've got a couple of weeks left of this 21-day lockdown period. Regulation has been put in place around the use of public spaces, but that takes on a different stance, or at least there's debate around the public spaces of sectional titles. Can you talk to us a little bit about the implications of these?
Yeah, there's been a bit of a debate about this, and not everybody is of the same view. And some people are strictly looking at the particular lockdown regulation, and I'm going to read that for you.
Okay.
It provides that every person is confined to his or her place of residence, unless for the purposes of providing for them, there's certain exceptions like essential services, etc. Now, when you look at a sectional title scheme, the owner of a unit also owns an undivided share in the common property. So in other words, part of that person's residence is a portion of the common property. And the argument now is that they therefore can still use their common property. Now, I'm of the view that that is definitely not the intention of the regulation. We must look at the purpose of these regulations, which was to confine people within their own personal space and to prevent the spread of the COVID-19 virus. So it would make absolutely no sense that people in sectional title schemes would be dealt with differently than people that are living in normal suburbs. So my view is no, that is not correct. Everybody needs to comply with these regulations, also the owners of sectional title units.
Great. So no walking the dogs, no using the private roads.
Unfortunately not. No.
No, we need to have clarity around that, because I think, as you said, it's about stopping the spread of this disease, and the exceptional circumstances around that kind of override all of the legal rules. And then finally, just to look at this 21-day period, it was sprung on us by the president. Many people have commended him for government's decisive action at this point in time. But prior to that, agreements have been put in place. What happens if a seller has changed their mind, or in fact that the person who is meant to be buying somebody's property is now changing the agreement. Can you talk a little bit about the legal aspect of lapsed agreements?
Okay, first of all, you need to distinguish between a lapsed agreement and the cancellation of an agreement.
Got it?
A lapsed agreement would be, for example, if a purchaser buys a property and it is subject to the approval of a bond, which has to be approved within a certain time frame. If that bond is not approved within that time frame and the parties did not agree on an extension, then it means that that agreement automatically lapses and there is no binding agreement between the parties anymore. That also means that there are no costs. The agent is not entitled to a commission. The conveyance is not entitled to a fee. And there would probably also be no bank fees. On the other hand, if the agreement has already become binding, all the conditions have been fulfilled, the bond has been approved, and now one of the parties has a change of mind, that would be regarded as a breach of the agreement. So in other words, they cannot simply, because of this present situation that we are in, decide that they want to walk away from that agreement. They could obviously by agreement cancel, but it might well be that one of the parties would not be prepared to do that. On the other hand, if both parties are keen to proceed with the agreement, but for one or other reason, because there's been a lot of delays with bond approvals, for example, or we can expect that, then they can come to an agreement in terms of which that condition is extended to provide for.
Absolutely.
So the conclusion of the agreement. And that is what would be my advice to clients, that they must carefully look at their agreements and decide what they want to do under the circumstances. And again, have an honest communication with the other party. That's the golden rule.
Complete sense. Is there anything else that you'd like to add at this point? You know, it's, as we said, it's exceptional circumstances. We're all focused on getting through this. What advice can you?
I would recommend that all the parties need to be honest. I've said that a couple of times, but speak. If you've experienced difficulty, don't wait. Rather speak up immediately and explain your situation, because that will help a lot. And I think that counts for all of us.
Fantastic. Thank you so much for your time, Mieke.
Pleasure, Selena.
So there you have it. Ensure your agreements are in place. Distinguish between legal and empathetic aspects surrounding these agreements. And when it comes to the forward plans delayed by the lockdown, crucial open communication should help avoid breaches or cancellations. Whether you are new to investing, an experienced investor, or an industry professional, hit the subscribe button so you can join us for the next episode of Property 24's podcast, as we look at the pulse of the issues impacting the property industry in South Africa.